forming the corporation. What do we need to know about how to form a corporation? We're going to focus on forming a Delaware corporation. So there are, of course, many different choices for that, but I'm going to focus on Delaware law. We're going to apply that in this class. And so to get there, we will preliminarily talk about choosing the state of incorporation and some of the considerations that a lawyer would make when deciding in which state to incorporate. As you know, you can incorporate in any state regardless of where you do business, and this can have ramifications for your internal affairs. The internal affairs doctrine says that a corporation will be governed by the laws of the state of incorporation regardless of where it's situated. The exception, quasi-exception, is California, who purports through Section 2115 to impose their laws on foreign corporations that have a majority business share there. But for the most part, you can make that choice of how you want to be governed, and there's many ramifications. We will then talk about the process of a Delaware incorporation, as that is the most common choice for companies that are looking to get outside funding or go public, and it's the default choice for many. That is changing as LLCs have come onto the scene. Other business entity types have changed the calculation, but Delaware is still the gold standard for corporations, so we will talk about that process in particular, both in the contents of the charter, the certificate of incorporation, and in terms of corporate formalities that have to be observed, and that's that really fun stuff of getting through all the Delaware general corporation law that we're going to do today. Then we're going to talk about the role of the lawyer, that's you one day, and the ethics that are pertaining there too. So lawyers have to represent situations before a corporation is formed. It's sort of a challenging new dynamic. You know, you have multiple people coming into your office, they may have competing interests, and you have to handle things differently when you're representing a group of individuals or an organization that has ownership interests. And then we're going to talk about one, at least discrete doctrine, and it's not something that comes up hardly ever in life, but it's something that comes up on the Pennsylvania bar. So we're going to talk about defective incorporation, in part because this doctrine is something that is tested on the Pennsylvania bar, and so it's certainly worth knowing about for that reason. It's something to avoid, and it actually does bring up some important points about agency law that will be relevant for our last module, our last chapter on binding the corporation. So let's start with our first topic of choice of the state of incorporation. And spoiler alert, in this class and on the exam, we're going to end up answering Delaware to then apply what we're learning. But let's first understand what this choice is comprised of. Generally, a corporation and its founders will have two fundamental choices to make: whether to incorporate in their home state, where they already are, or Delaware, although there are some reasons to organize in places like Wyoming and South Dakota as well. I'll talk about that in a minute. For our sake, though, corporations that you're thinking about will probably be deciding between Pennsylvania or Delaware. So what are some pro and con? What are some reasons that people incorporate in Delaware? Mary Beth.
The courts in Delaware are very well versed in corporate law and they handle it well.
Yeah, there are in fact specialty courts in Delaware that really do almost exclusively corporate law. And so if you have a corporate law issue that comes before the court, you know, it's not good. You go down to the courthouse down here, and the judge hears a criminal case on one day, you know, a divorce issue on another day, some tort, you know, or a contract claim on a third day, and then a corporate issue on a fourth day. And, you know, it's hard to be expert in all these areas, and as we've learned, corporate stuff is a little technical. So it helps that in Delaware, you get access to these specialty courts that specialize in ruling on matters of corporate law. And so lawyers like that, although business people might say, okay, whatever, I don't care, I'm not going to get sued, but we know better than that. People get sued and issues happen all the time. This has also resulted in more law. So we actually have more certainty about how Delaware courts will rule, because there's just more case law. There are more corporations in Delaware, they have more cases heard there, and as a result we have more legal decisions. And as you learn from legal writing, it's kind of hard to come to a conclusion on how a court will rule if it hasn't been done before. You have to reason through all the policy. Much better if you can find precedent on point. And that's much easier to do in Delaware. Other reasons people like Delaware. The courts, the law, yeah.
Without being super specific, I think that Delaware leans on the side of, you know, basically
That's certainly true relative to California. So managers might prefer Delaware because the shareholders have less rights vis-a-vis the managers than they would in some other jurisdictions, most notably California. This is a question of whether this is like a race to the top, race to the bottom. There's some theory about that, whether this really is good or bad for society. But managers seem to like Delaware. Delaware will say that it's balanced, but certainly there are states that have more shareholder-friendly regimes, like require or certainly more protections for minority shareholders. And so managers like Delaware in part because it makes their lives a little easier to manage the company. Other reasons people like Delaware. Yeah, Michael.
No taxes. Well, lack of taxes.
So actually, there's a lot of different taxes that apply to corporations. Delaware loses from a tax perspective. Delaware is expensive. You really pay a lot to be in Delaware. So actually, what we're going to see on the next couple slides about cost, Delaware has high cost. And so that's not a reason to choose Delaware. It's a reason not to choose Delaware. So a reason not to choose Delaware is for tax reasons. There are much more tax favorable states. And if you are a foreign corporation, meaning you're not domiciled in Delaware, you would then have essentially two masters. So if you are domiciled in Pennsylvania and in Delaware, you're going to be paying Delaware taxes as well as complying with regulations registration here in Pennsylvania. Delaware adds cost. That's not a factor in its favor. That's a factor against it. Other reasons people like Delaware.
Can we just go back to the internal affairs for
Mm-hmm.
a minute? If you're telling somebody, like you're planning to incorporate in Delaware, would they have to go to the Delaware Court of Chancery to resolve their disputes? Or
Yes.
so any dispute they have, they would have to go to Delaware?
So this is a jurisdictional question. It's like kind of a civil procedure type question. The Delaware courts generally hear claims on matters of Delaware law. There are some situations where a Pennsylvania court could opine on Delaware law and apply the law of Delaware while sitting in Pennsylvania. But the effort for both parties usually is to get those cases heard in Delaware. And so there are it's more of a civil procedure question as to the absolute definition. But the short answer to your question, most cases about internal affairs and governance and voting and minority rights that involve Delaware corporations would be heard by Delaware courts, even when those companies have headquarters elsewhere. Most Delaware companies are not headquartered in Delaware, not the big ones that matter. So we'll see a number of those cases as we go forward. Vantage Point, for example. That's a Delaware hearing decision, but they were residing in a different state. Yeah. Other reasons people like Delaware? Yeah. Yeah, easier. It's easier. They have a lot of you have a lot of online materials. So you can, for example, in Delaware, you can file something on an expedited basis. It may seem like a small matter, but in Pennsylvania, you can't. In California, you can't. You have to then wait until they get around to it. So you don't have as much certainty. You do have to pay more for this, but if you have an important transaction, if you're trying to file a certificate of merger, you got to get the deal done. Delaware is going to be able to rush that through in an hour. And they can also pre-approve things, which makes it easier. And they have a very good website, and we'll see something in a minute called Delaware One Stop, where you really click a button and it's all of the registration you need to do all in one place. So it really facilitates organization. I mean, this is a whole state whose business is run around doing this properly. And so you can get someone on the phone when you need to call. I mean, that's nice, like literally customer service. Now, I remember working in California at the law firm, and I'd have the phone on hold for 3 hours before someone pick up. It's nice that you can do something else in the background. But, in Delaware, you can get a live person on the phone usually in 2 or 3 minutes. It's a huge help. It's worth a certain amount of cost because you have more certainty about that. The forms are more standardized. That's another factor. Since many people incorporate, it's sort of a virtuous cycle or a vicious cycle, depending on how you see Delaware, but because a lot of people have incorporated in Delaware, there's precedent, not just in terms of law, but in terms of forms. And so if you want to form a Delaware corporation, we're going to see that's really easy. We can do that with like an online service and get documents produced very easily. You want to form a Wyoming corporation, you're going to have to do some legwork. Because those forms, they might be available in some book on Wyoming law, but they're just certainly not as plentiful or as available because Delaware has been the default for so long. Yeah.
I liked Delaware because of, those third-party companies that would be the registered agent, like corporation, service, company, or
Yeah, so you can actually pay a registered agent to do a lot of the work for you, and some of them are really cheap. You can have, so we'll come to this requirement in a minute, but if you are not domiciled in the state, you have to appoint someone who can receive process so that you can be sued in that state, right? So if a lawsuit in Delaware is filed, that will be served in Delaware. There needs to be someone to receive that process, and that person would be a registered agent. And a registered agent in Delaware can be as cheap as $45 a year. You can get one that offers a lot more services too, and there's like 150 of them or something. So there's a lot of competition for registered agents. I don't know how many registered agents there are in Pennsylvania offhand, but I can tell you it's a lot less. And the competition is not there. And similarly in Pennsylvania, Harrisburg is concerned about a number of different issues. They're not focused 40%, 60% of their energy on having excellent corporation law and Secretary of State services. They're focused on a number of matters. In Delaware, that's a huge part of their income, that and the darn bridge.
I can tell you a fact about the Pennsylvania Department of State.
Yes.
The Bureau of Commissions, Elections, and Legislation has only 18 employees.
Wow.
And that handles all kinds of stuff. So when you call, they sometimes have to draw people from the corporations, it's quite a order on there.
So the people working in the corporation department are subbing in at the elections office, and probably vice versa in Pennsylvania. Less likely to happen in Delaware. Yeah. Yeah, so Pennsylvania, Stratford Resources, right? So those are all things to think about. When you incorporate, you kind of get married to the process here, and that can be a very arduous process. But that said, it's cheaper. And that's the big reason to do it. It's cheaper, and there are some reasons to incorporate in specific states for specific purposes. Like, for example, just an example, Pepsi's incorporated in North Carolina. Why North Carolina? Well, North Carolina happens to have some state statutes that make it harder to take over a company, that make it easier to defend against a hostile takeover. And so Pepsi decided that, due to their structure, what have you, it's beneficial to them to have less risk of takeover. And so North Carolina did that for them. For those who know more about credit, I know that American Express and a lot of other credit card companies, Discover, are in North Dakota. And so North Dakota obviously has some kind of favorable law for that type of business. Maybe they have higher usury. I think that might have been it. They have higher usury limits. And so they basically you can have the maximum usury available in every state. Usury is like the maximum interest you can charge. And so I don't know if that's 29.5% or 35%, but my understanding roughly is that North Dakota has a very high limit, and so then you're only subject to the limits in the state, as opposed to if North Dakota or if another state had a 19.5 limit, you can only charge that much, and so they can take more of your money if they're headquartered there. So there are special reasons for special companies. Who forms a corporation? What do we call a person who forms a corporation? Yes?
Incorporator?
The incorporator. That was an easy one. You should be able to get that one on the, right? You had to guess, right? The incorporator. And the incorporator is one or more persons. So you could have multiple incorporators. And what do they do? How do they complete the incorporation process? Yes?
File paperwork with the Secretary of State,
And yes, paperwork. What exactly do they file?
articles of incorporation.
So I'm glad you said articles, because that's half right. It's the same concept, but in Delaware uses different names for different things. Delaware calls it a certificate of incorporation. Your book is referring to the Model Business Corporations Act, and the Model Business Corporations Act calls it the Articles of Incorporation. But what jurisdiction are we dealing with? Delaware. And so we're going to use Delaware's terminology, and Delaware calls out the Certificate of Incorporation. So go ahead and refer to it as a certificate of incorporation. That's what we'll be filing in Delaware. And that certificate has information, which we'll go over, including the corporation's name, its authorized shares, the incorporator, and its purpose. Oh, my slide be. Oh. What's that? Okay, anyway. Process of view. Okay, so the keynote works a little differently than PowerPoint here. That's okay. So, what words must be included in a corporation's name? Yes?
Corporation and corp.
Corporation, corp, there are other choices. Corporation, corp, inc, club, company. There are a number of words. They're all listed in Delaware General Corporation Law, Section 102. And that list includes inc, incorporate. Basically, abbreviations of all of these words are included as well. Association, company, which would be co, club, foundation, fund, incorporated, or Inc., institute, society, union, syndicate, or limited. And if you need to look that up, it's right there. By the way, you can Google just DGCL. It will get you right to the Delaware General Corporation Law. It's in Section 1, name. So all of this is information you get online. There are also some words it cannot contain. What are words that cannot be contained in a corporation's name unless it has sort of special dispensation? You can't call it a bank if it's not a bank. And you can't call it a trust if it's not a trust. And so there are special rules about what is a bank. Banks have to register as banks. If you're not a bank, you can't call it a bank. There was also some cases where companies, like online learning companies, tried to call themselves university, and there was some dispute over whether that name was appropriate. So go ahead and put university into your list of names not to use, because that's gotten some people into some issues before. So basically, avoid those words, use these magic words. They are required. Why are they required? Why do we require names like Inc. and Incorporated? What do you think, Joe? Why would we require a company to have those magic words on its name? What does that do?
Signifies what kind of company they are.
Yeah, it signifies, and it signifies, it does, right, the reason we have these names, it signifies to the world that this is a limited liability entity. It says to the world that if you do business with this company, you can't sue its shareholders. And those magic words are important because, as we'll see, limited liability is a double-edged sword. There are some societal consequences for having it. So we're going to require some really clear disclosure of that, and something like Incorporated puts the world on notice that the shareholders are not going to be liable if that company doesn't pay its bills. Okay. Who are incorporators? We talked about that, Section 101A. So an incorporator, I'll also mention this, can be another company. An incorporator can be any person, partnership, association, or corporation. Now this is distinguishable from a requirement for directors. What's the requirement for directors? Can directors be corporations? Directors cannot be corporations. Directors can only be natural people, human beings. Whereas an incorporator could be another corporation. So that means that before that corporation does anything, that incorporator needs to go, right, and be replaced by the directors. And so the other lesson from this is that the incorporator can only incorporate the company. They cannot authorize any further changes. So the incorporator steps aside as soon as the incorporation is complete, and a natural person has to take the helm. And only a natural person can be a director of a corporation in Delaware. And the way you file under pursuant with Section 101A, again, right at the beginning of the statute, you file the certificate of incorporation with the Division of Corporations in the Department of State. All right, corporate purpose. For what purposes can you organize a corporation? Yes? Any lawful purpose. Any lawful purpose. So you can't run a corporation called Hitman Co. Turns out that it's illegal to put a hit out on somebody, and so you can't create Hitman Co. and organize a corporation for the purpose of assassinating your neighbors. Okay? But any lawful purpose will do, and as a result, most corporations will form with this any lawful purpose language. Next week I will show you a model form for a Delaware Certificate of Incorporation, And it doesn't even have a blank space for purpose. It just says any purpose, any lawful purpose in the form, because basically nobody is going to limit their purpose at that stage. There's no reason to limit it. It doesn't do you any good. The only time you'd want to limit a corporate purpose is if you have a nonprofit. We don't focus on nonprofits here, but a nonprofit has to have proscribed, circumscribed action so that it maintains its nonprofit status. And so in that case, you want to have that limitation. But most corporations incorporate for any lawful purpose. You also have to disclose the number of authorized shares. We talked a little bit of authorized, outstanding, right? We're going to come back to that in our very last lesson on capital structure. Why are the number of authorized shares a required element of the certificate of incorporation? What does that matter? What can you learn from the number of authorized shares? Why would someone want to know that? Who would want to know that? Yeah. An investor, right? Because that tells them the total amount of pie that's out there, so they know how big their slice is. An investor needs to know this information. There's also some information on there that investors don't need to know called par value. I'll get back to that in a minute. But the idea of knowing how big the pie could be, that's really important, because otherwise you don't know if 1,000 shares is a big slice or a small slice. And at the end of the day, it's all about percentages, not about aggregate numbers. So if there's 1,000 authorized shares and you buy 100 of them, you have a big old piece of pie, right? A tenth. There's 10 million authorized shares, you don't have much at all. You barely have a crumb, right? So the authorized shares is really important for investors. And so it's required. How about a registered agent? We briefly touched on this. I mentioned a registered agent is another aspect that is required. Why do we require that? Who would want to know the registered agent? Yes?
Someone who's going to sue you?
Yeah, so you know how to sue them, right? In order to sue a Delaware corporation, you have to serve process in Delaware. And in order to serve process in Delaware, someone has to receive service of process. That person's a registered agent. Has to be listed because it has to be readily identifiable. Go on the internet and find out how to sue this company. Delaware requires that. Part of the privilege of being able to incorporate there is the fact that you get to be sued there. Question, Michael?
Do you just go to the Department of State to find the address to non-service station?
Yes. Yes, I can show you that actually. There, let's.
I just want to sue Kmart or something like that. I had to do that, but I wasn't sure how to get the address.
So I don't know if that's I don't know if Kmart is in Delaware, but if we go to the Delaware corporate name search, get a business entity search, first link there. Maybe Walmart. I think Walmart was. All right, there's a lot of Walmart. I don't know. So apparently they have a property company. It should have come up. Been here telling you how great their website is, and should be able to click on this and get all the relevant information. Why does it keep bouncing back? You see, it's looping to the front site here. I'll try another one.
Maybe it's supposed to open in a new page on the internet.
Oh, I see. There's like a JavaScript thing here. Yeah, let me. I think there's some issue with this browser and JavaScript. Well, take my word for it. That's how you find it. It's really pretty easy. A couple steps. Hopefully you don't have a lockdown Podium browser when you're trying to look at it, and you can enable pop-ups. But I think that's right. I don't remember if you need to pay $10 to run a search to get that information, but I think it's free. I think it's just you click through, and so. Anyone, by the way, wants to try it from their desks here, you can just, did you get it? It worked?
Yeah, it is, Walmart Inc. is there.
And you were able to click through and get the information? So how do we sue Walmart?
Let's see where the registration information is. Oh gosh, there's a lot of information.
We'll look at it all. We're going to go through that.
Yeah, it's got the whole report.
Yeah, so you've got a ton of information out there. So you can check that out and see what information is freely available. And then for, I think, $10, you can find out if they're up to date on their franchise taxes and things like that as well. I think there's a full form of all their history. For $20, you get a whole list of every name change they've had, every merger they've had as well. Yeah.
Corporation Trust Company will build.
Great, Corporation Trust Company. So that's a registered agent, and if you want to sue Walmart, you go to the Corporation Trust Company and you serve process there. So thank you for that. I don't know why the podium computer didn't get around to it, but apparently it's a pop. JavaScript, they're advanced, more advanced than our podiums here. So that's why we have the registered agent, easy to find, and that way you need to sue someone in Delaware, it's 3 mouse clicks in a search box. The certificate of incorporation must also have some information about some people that are behind the company. So which of these things is true? The certificate of incorporation must include come on, there we go. Which of these must it include? Does the certificate of incorporation have to name the incorporator? Yes.
I think it does.
It does. The incorporator is required. Are the shareholders, do they have to be named? Do you have to name the shareholders? No. How about the directors? Are they named? Only if there's an immediate switch of the incorporator to the directors, so they're automatically appointed. But you can get away from that by having a separate document called an action by incorporator, which I will show you next week, and it's considered a best practice. So directors, that's a maybe. Directors are if the incorporator is automatically replaced by a director, then you do have to name that director. But if you go through this one additional step of having an action by incorporator, you don't need to list the directors. And that is a best practice. So you can go ahead and say, yes, you don't have to list the directors, but you have to file you don't actually file it, but you would have an action of incorporator. And I will show you that document next week. We will build that document. And finally, the officers. The officers have to be mentioned on this form. CEO, CFO. Yes or no?
Oh, no.
Not required. Not required. So the only thing that has to be on here has to be, the incorporator has to be on the certificate of incorporation, and we can avoid the directors as well. So I point this out because I will show you a slide where I break down the difference between what's on the annual report and what is on the certificate of incorporation. Some of that additional information is required on the annual report. Okay, how many directors does a corporation have to have? Does it have to have any? The answer is 1. The minimum is 1. Every corporation must have at least 1 director. DGCL, by the way, that's short for Delaware General Corporation Law, because that's kind of a tongue twister. DGCL section 141B says the board of directors of a corporation shall consist of 1 or more members, each of whom shall be a natural person. Do these directors have to be stockholders? Do the directors of a corporation have to be stockholders of that corporation?
They can't be typically, or like it has to be in the, whether they can or can't be is in the articles of incorporation, right? Or am I like confused?
Well, I think you're confused. Yeah,
Okay.
so yeah, the articles of incorporation will go back to what they require. It does
I'm
not.
sorry, I read the question wrong.
Ah,
Yeah,
do the directors
No.
can they be directors even if they're not stockholders?
yeah.
Yes, they can.
And that's
Yes,
for
they.
like a closed director or something, right? Isn't there a term for that, or am I just?
There are 2 types of directors. There are inside directors and outside directors. And so the reason that we have that distinction is because not all the directors have to be stockholders. Directors that happen to be stockholders are inside directors. Directors that are not stockholders are outside directors. And the fact that there are outside directors, there's your answer to the question. The directors do not need to be stockholders. Now, I think to your point, the certificate of incorporation can require this. It is an optional requirement, but it is not mandatory, and it's very uncommon. Maybe in a closed company, but it's sort of a why kind of thing. It's uncommon. But the general rules, it's not required, but the certificate of incorporation has a lot of optional provisions. I'm not going to go through all of them. You can check them out in section 102. It's about 3 printed pages worth of content on that, and one of those aspects is you can limit who can be a director. So let's take a look at a certificate of incorporation. Is this valid? Does this contain all the information required by the DGCL for a valid certificate of incorporation? Who thinks that this is sufficient? That contains all the required elements under 102? And who thinks they see something missing? No one's going to volunteer on that one, huh? What's missing? Is there anything missing? This is a complete document. This is a complete document. There is not anything missing here. We have the name of the corporation. We need the name of the corporation. We have the address of the corporation's registered office. We have the total number of shares and the par value of those shares, or no par value. I'll talk about par value on the next slide. We have the nature of the business, any lawful purpose, that's the common one. And we have the name and mailing address of the incorporator, which again could be a corporation, right? So there's a way to sort of obfuscate the address of any natural persons on here. And it's signed and filed. So this is as bare bones as you can get with complying with 102. There are some formal requirements in terms of kind of the look and feel that Delaware will accept, but this meets the letter of the law. Again, those 5 elements that need to be present are here. Name of corporation. Address of the corporation's registered office, meaning the name and address of its registered agent. That isn't necessarily the corporate headquarters. That's where you can serve process. It has to be on there because you have to be able to sue the corporation. You need to have the total number of authorized shares and either their par value or that there is no par value. We will talk about par value. We have to have the name and mailing address of the incorporator, but keep in mind that could be a corporation, so it's not necessarily a person's home address, but it could be. And we need to have the purpose, the business purpose. And usually, if not always, it is any lawful purpose. That meets the bare bones requirements of a charter, of a certificate of incorporation under 102. So what is this par value business? So par value is kind of a anachronistic concept. So historically, corporations had the concept of par value to protect investors because a corporation is not allowed to sell its stock for less than its par value. And so you would know that if you were that no one was getting a better deal than that. Now that has become completely unnecessary with public markets where you know at a fraction of a millisecond what everyone is paying for every share of stock. And in private markets, when you have sophisticated investors, they generally will ask for this information and they should receive it. They should ask for, and they will receive, or they shouldn't invest, the price that everyone else has paid. And they can have contractual provisions that limit how low you can sell future rounds of stock for. It's a more complicated nuance of preferred stock provisions. So why do we have this still? Well, it's sort of an archaic holdover, but it does have this function. You may be, by the way, more familiar with par value with referred to bonds. Some of you who do more finance work. Par value is the face value of a bond, the original issue value of a bond. So if you go and if a bond is a debt instrument, so a corporation can issue a bond, it's basically asking for a loan from the public markets. And so a corporation can do this, and they could sell the bond for, say, $1,000. So they receive that $1,000, and then they pay you a coupon for a period of time, and then they redeem that amount. So if it's a $1,000 bond with a 10% coupon over a 10-year period, that means that you pay the corporation $1,000 today. It's $1,000 face value. And then every year they pay you 10%. That's $100. And at the end, and literally, my grandpa used to have these. They literally used to be coupons on them, like that you'd like clip, like the dog walk ad kind of things. I mean, little dangly pieces that you'd cut off and you'd send in, and they'd send you money. So you'd clip the $1,000 bond, 10% coupon. You know that it's going to be $100 every time you send it in. You clip the coupon, you send it in, you get your $100. At the end, you send the certificate back in. They give you the $1,000 back. So in this very simple hypothetical, this particular bond would have returned $2,000 over 10 years with an initial investment of $1,000. And so you would make 100%. Right? So that's a nice investment. But you can also, if you have this bond, right, let's say you've clipped a coupon, and you now want the money now. You don't want to wait a year to clip another coupon. You could sell that bond to another person. Okay? You could take that bond, sell it to another person. And how much they'll value it, well, that depends. Depends on how the corporation has done since then. If the corporation has done better, maybe they'll even pay more for it. If the corporation has done better and interest rates have gone down, I mean, nowadays 10% sounds awesome. If you could get a 10% return from Google, you would pay potentially more than $1,000 for that, because you can't do better than that right now. On the other hand, markets could go the other way. So the value that a person will pay for a bond can change, but its original value is fixed. It's written right on the instrument, and that's why it's called its face value. It's how much it was originally paid for, and that is also called the par value. So that concept's a little more straightforward. Similarly, though, with stock, the idea with par value is the lowest amount stock can be sold at. The practical import of all this is basically you set your par value to an infinitesimally small number. And that way you never run the risk of selling the stock for less than the par value. Now, you don't even have to set it to a penny. A penny is probably too much for some of these. Depends on how many shares you have. But if you're issuing 10 million shares, which is sort of common for a startup company that is trying to attract investors and trying to hire a large number of employees and give them stock options, you would set that par value to 0.01 or something really small like that. So it becomes a meaningless number, and of course you're not going to sell it for less than that, and it's just sort of an archaic holdover. As a result, more modern systems allow you to have shares without par value. But that's at least the concept, and you will see it fairly often in Delaware charters. All right. So this all has to do with sort of some information about the capital structure. The capital structure meaning how the shares are organized. So the other aspect that's going to be in a charter, not required, because a corporation can have a very simple capital structure. The minimum capital structure would be 1 share of common stock. That's sufficient. You can have a corporation that has 1 share of common stock, and that's pretty simple. But you can also have a lot more complicated structures. You could have preferred stock, which have different rights, and so on and so forth. And so when you get into deals like that, that's when venture attorneys develop much more robust and complicated certificates of incorporation. But every share of stock, every class of stock, every series of stock, the fundamental rights for it need to be in the charter. And so if you have a more complicated venture-backed company that's issued preferred stock, that's going to be in the charter as well. It's not a requirement because you don't have to do that, but if you're going to issue preferred stock, you have to authorize it in the charter, and you have to specify the rights there. So what does capital structure include? Just a quick review, a quick recap. Capital structure means debts the company has issued, just like the bonds that I had talked about. Capital structure includes common stock, which is going to get the residual from the company, and preferred stock, which is specific to venture capital investing and other types of private equity investing, which have a lot of additional, what we call bells and whistles, additional rights. What are some of those rights? Just for your edification, what kind of rights come with preferred stock? They may have additional voting rights. For example, the Series A shareholders might have the right to block an issuance of Series B stock, so they might get additional voting rights. If the company sells in a merger, or if it liquidates because of bankruptcy, they usually get paid first, and they may get paid a multiple of what they invested. It's called the liquidation multiple. They may get dividends. Dividends are kind of like that coupon for a bond, where if it's a mandatory dividend, they get a certain amount of money on a regular basis, or they might get rights to special dividends. They get paid special dividends first. And they might, in the charter, specify that the preferred get a board seat and some control rights, in addition to those voting rights, that they get to always pick at least one member of the board. And so that can be very valuable as well. So again, what you need to know for this class, not venture capital class, is that there are 2 essentially flavors of stock: common stock, which gets the ordinary rights, and you have a simple charter; preferred stock, which has additional rights such as these. These rights would need to be included in the charter. Preferences. It's called preferred stock because they get preferences. How many shareholders does a corporation need to have? Can they have 0? Can you have a corporation with no shareholders? Is it 0 or is it 1? That's really the question. It's not 2. I'll give you a hint. It's not 2. Is it 0 or is it 1? It's 1. 1. You can't have a corporation, can't have a non-stock for-profit corporation You have to have some owners at the end of the day. You can't have a non-profit, non-stock corporation. We're not going to deal with those in this class, so you need to have one shareholder at least. But again, one shareholder and one share of stock and one director, they can all be the same person, is fine. That meets the minimum requirement. How do you change the authorized number of shares? How do you change the authorized number of shares? Anybody know? Where is the authorized number of shares listed? Yeah. On the certificate. So in order to change that number, you have to amend the certificate. And so, very simply, to change the number of authorized shares, you have to file an amended certificate. You have to file an amended certificate with the Secretary of State. And that's how you would change the number of shares you authorize. All right, so we're going to talk a little more next week once we see the documents, and then substantially more in the coming weeks about how we animate the corporation once it's been incorporated, what happens after incorporation. So this is just kind of your sneak preview, right? So you don't have to worry about catching all of this. But after the corporation is formed, there has to be an organizational meeting. And at that meeting, a number of things are handled. It's going to make a lot more sense when you physically have a copy of the organizational minutes in your hands. So you will get that. By the end of class, by this time next Wednesday, you will have a document that says organizational resolutions and has all these resolutions in it. So this will become more tangible. But just so you have an idea, the type of things a corporation has to do after it's formed, it has to ratify the directors or appoint the directors. It has to appoint officers who are going to act for the company. It has to adopt bylaws. It has to choose a bank, so a corporation needs to have a separate bank account, authorizing that bank account, authorizing the issuance of shares and the price of those shares, any other agreements. There are a number of other things that come up, and we will see all of those on a document, and that's the post-incorporation matters. Another aspect that we would think about and we will see is the action by Incorporator. As I mentioned, the Incorporator has a role to play that ends as soon as the incorporation is complete. If you don't want to disclose the directors on the Certificate of Incorporation, then you need to have a separate action by Incorporator where after the corporation is formed, then the Incorporator sort of hands the corporation over to directors, and that avoids the need to list the directors. I will show you that document next week as well as the organizational resolutions. And then the other document, which we're going to come back to today, is that annual report, which needs to be filed and also contains some information. So what is on that? This is a quick summary then of what is required on the certificate and the annual report. So as you can see, the annual report is going to add certain features. Most notably, the name and address of all the directors and the officer signing the report. That is a key addition. So now the names and addresses of the directors get disclosed on the annual report, as well as the corporate officer who signed the charter, who signed the report. It's usually going to be the secretary. It could be the CEO. Doesn't matter really. One of the main, could be the president. But now that information is going to actually come out. So just in case your clients thought that they could remain secret forever, remember that directors are natural persons and they have home addresses, and those get filed with Delaware. And so if you don't want that to happen, there are other forms in other states that have fewer disclosure requirements, but this is a requirement for a Delaware corporation. Not at the instance, but after a year. And that surprises some people because they go through the process and they think that this isn't going to be disclosed, and then they get the annual report a year later and realize that they're now obligated to reveal their home address. Some people really don't want to do that, right, for a number of reasons, so something to keep in mind. So before I jump into the next topic of sort of role of lawyers and ethics, any kind of questions about some of those basic formalities? You should come away with this knowing a few basic things. One, you should know the 5 things that are required in a Delaware charter. You should know that that charter has to be filed with the Secretary of State. You should know that it has to be amended if you're going to change the number of authorized shares. You should know that every year you also must file an annual report which has more disclosures, including the names and addresses of the directors and the officer signing the document. And so after that, you should be able to look at a corporate charter, a proposed charter, and determine whether or not it meets those basic elements. And like I mentioned, we will see one next week. There are also many optional elements. The one we build is going to have several of those optional elements. So I'd like you to kind of be able to determine which of these elements are essential, required, mandatory, which are optional, additional, extra. Yes? These slides? Yeah, I'm happy to post them. But by the way, as I mentioned, if you just pull up Delaware General Corporation Law, I mean, it's all there. It's all there. And it's in, I think this material is in the casebook too. So you have it in a lot of different ways. I will gladly post these slides, but take a look at that. If you have any confusion on it, there's not a lot of reading load for the rest of this course. Take a look at that statute. Just a couple pages, section 101, section 102, right at the beginning, and it's also in the casebook, and it will be on the slides. A couple things to keep in mind.